Calling the last case, which is Janice Sherman versus Progressive Michigan Insurance Company and John Doe. This is a mini oral argument on the application, 15 minutes per side. You have 2 minutes of fire free, and if you would like to reserve any time for rebuttal, you may do so, but just we ask that you keep track of it.
Thank you. Good morning, Justices. Pradeep Savantha Nathan on behalf of the plaintiff appellant. It is an honor to be here in front of you today. I want to start with a very simple and straightforward statement of law. Pursuant to this court's rulings under Bozzi and more recently C-Spine and Wallace, rescission is an equitable remedy. Again, rescission is an equitable remedy. And with that in the background, the parties were asked by your honors to answer 3 questions, which in short are whether the Court of Appeals applied the correct deferential standard of review to the trial court. 2, if not, what is the proper standard of review? And 3, if the trial court erred, should there be a rebalance in the lower court? The answer in this case is no. The proper standard of review was not applied by the Court of Appeals. The proper standard when reviewing an equitable remedy, again, is an abuse of discretion. The Court of Appeals instead applied a de novo review across the board. This is important because a pure de novo review of a well-thought-out, well-balanced, and principled ruling in equity takes all discretion away from the lower court. It takes all discretion away from the trial court. And that is not what we want. We want our trial courts to be able to do their jobs. As detailed in my brief, the correct standard of review for this nuanced issue is actually much more involved. There are 3 separate layers here. Pursuant to Pioneer State Mutual, factual findings such as domicile must be reviewed for clear error. Pursuant to Wilmore Moody, statutory or contractual interpretations such as whether Sherman made a misrepresentation is reviewed de novo. And then finally, pursuant to Pioneer and Wallace, the selection of the remedy is reviewed for an abuse of discretion. That did not happen here. And so the ordering of the payment of additional premiums must be reviewed for an abuse of discretion, which did not happen, and therefore the Court of Appeals must be overturned. Thank you. I'd like to take some questions, please.
You said Wilmore Moody was set forth a de novo review? And it does at one point, but at another point in the opinion, it says rescission shall only be granted on the sound discretion of the court. So it sounds to me like there's de novo and then there's some abuse of discretion in there. So which way should we go?
Abuse of discretion is the correct standard, and I note that you, Justice Zara, noted that in your footnote 46 of the Wallace decision, which I think you stated was an inadvertent application when they wrote de novo. But abuse of discretion is the correct standard here. Every other case that has come through this court has noted, whether it's Bozzi or any of the other cases, has stated abuse of discretion is the proper standard when we are selecting remedy.
Okay, I thought you indicated it was a de novo review. I might have misunderstood your position.
De novo review for the contractual and statutory interpretation, but not for the selection of remedy. Selection of remedy is purely abuse of discretion.
Right. And the actual selection or how the remedy was fashioned wasn't in fact an issue in Wilmore Moody or Esurance, right?
Correct. Yes.
Okay.
So, Counselor, if it's an abuse of discretion, we look at what the range of principal decisions are. What if the position of the Court of Appeals here is that the range of principal decisions don't include what the trial court did? So what happens then?
Well,
So
first I would.
let's say they had applied, in fact, that correct standard abuse of discretion and say, this isn't within the range of principal decisions. What next?
So, first off, I would disagree with that because there is, as noted in page 3 of our brief, there's a section of the policy itself that's called changes. And it states that if there is a listing of an incorrect address, we can adjust your premiums. And it goes through under what circumstances we can adjust your premiums, and it says if your mailing address and your residence address is incorrect, or the principal garaging address of any covered auto is incorrect. So not only is this within the range of well-principled remedies, it is actually something that Progressive has contemplated and actually thought about and included in their policy. So when the judge...
But the presence of other drivers in the home is not part of that provision, is it?
that
The
is
failure to disclose other drivers over 14?
That is not in the specific changes section of the policy, but it is within the, well-principled outcome that was ultimately decided on here. What was decided on was the higher premium of moving the policy to Detroit rather than paying for the additional person in the Clinton Township address. So if anything, the lower court gave more deference to Progressive's argument that this would have gone up 75% if she was in Detroit, which is another issue, unrelated. But the trial court eventually gave Progressive that argument, saying that, hey, we're going to charge you more because we're going to say this policy was in Detroit, and there was no other family member in Detroit.
Counsel, our law, as argued by sister counsel in this case, our law on this has said that reformation is appropriate when there's mutual mistake or fraud on one side. And I'm wondering if you could respond to that and why you think that doesn't apply here.
So I think that I don't think there was a mistake on just one side. I think that there was issues on both sides. Progressive under Bozzi, and then more recently under Wallace was decided when this all happened, says that if you want to rescind a policy, you have to come to court to do that. What they did was they unilaterally rescinded the policy before any lawsuit was filed. So Progressive does not have unclean hands. There is issues on both sides. Reformation makes sense when we have these circumstances of facts. I think the trial court took into account all of that.
Isn't that, though, is that really the relevant time, is looking at Progressive rescinding the policy? Aren't we looking at weighing the conduct at the time of, like, the accident or the time of the policy, right? We're looking at, and there could be circumstances where there is inequitable conduct, innocent maybe even, on the part of the insurer. Say, that they told the insured something wrong, or their form or whatever online platform was ambiguous, or, led them to put down the wrong answer or something, and then maybe you're weighing that. But here, the only sort of problematic conduct by Progressive is this question of rescission, right? Or is there, that's what you're asking us to weigh against the innocent mistake of the plaintiff?
There's a lot of factors to weigh here, and I think that the trial court did a very nice job of balancing all of the issues here. Only the trial court knows about all of the issues involved, and has that ability to understand, sort of everything that's going on in the case. There's external factors about whether or not Progressive should be charging 75% in urban areas versus non-urban areas. There's issues as to whether or not Progressive should have been able to rescind before a lawsuit was filed. There's issues as to whether or not Ms. Sherman was actually living in Clinton Township or Detroit. Her house was
But
flooded.
don't we have a factual record of what the trial court based her decision on?
So-
We have a factual record on which the trial court based her decision, right? So
Correct.
that's what we're reviewing, and I guess, like, to be maybe more specific to or following on Justice Thomas's question, if the Court of Appeals or us find that that was wrong, is the remedy the remedy that we would order, does it go back to the trial court and say what you did was incorrect and here's why? do it, now exercise your discretion under our guidance? Or is it to, as the Court of Appeals said, no, there was no principled reason, of what she did, or the trial court did, so therefore, rescission was appropriate.
If this court finds that a fact was incorrectly decided by the trial court, that's reviewed on a clear error standard, we would send that back down for the trial court to look at that again. If the trial court, if this court gives deference and does not believe that there was a clear error on the weighing of the facts or the determination of the facts, then this court could send it down to the trial court to rebalance and determine if appropriate remedy is a change in premiums or rescission or just a complete denial of Progressive's motion for summary disposition.
Can you help me? I'm struggling with, even if there's a dispute about the address and maybe where she was living or where the cars were housed at what time and that sort of thing. Am I correct in that the failure to disclose other drivers in the household applies regardless, right? She didn't disclose the driver in the Clinton Township. I think it was her daughter in Clinton Township, right? She didn't disclose her son and maybe somebody else in the Detroit home, right? Was there in fact a fact question about that disclosure of drivers over 14 in either home?
That is a fact question, and that's a fact question that the trial court weighed and balanced as part of its well-principled outcome that it.
So there's a question of whether she in fact did disclose those drivers.
There's a question of fact as to that, yes.
Okay.
I will save some time for rebuttal. Thank you.
Thank you.
Occupational hazard. Good morning, Justices. My name is Caitlin Kramer. I represent Progressive in this case, and I just want to start out. I think Justice Kavanaugh, you just hit I think, very important part in this case. The factual record is actually very well settled. I would direct you first to plaintiff's response to our motion for summary disposition, plaintiff's briefing on appeal in the Court of Appeals, and indeed plaintiff's application to you at first. No dispute regarding the misrepresentations is presented there. No dispute regarding failure to disclose. No contesting of that fact is ever presented. The sole argument to the Court of Appeals was that reformation was proper and that, as Brother Counsel stated, that the trial counsel engaged in a very fair balancing by ordering reformation at the trial court level. At the trial court level for the motion for summary disposition, the only dispute was that was a debate about the workman factors regarding residence and domicile and the materiality evidence that was provided by Progressive. Progressive provided an affidavit that, as you noted, Justice Kavanaugh, states that both the Detroit versus Clinton Township debate and the failure to disclose multiple household residents, a different car that she had the title to, and a different driver for that vehicle, all of those factors led to a premium increase. All of those were factors that supported rescission. You've asked us about the standard of review that should be applied to this case. Plaintiff has responded that the Pioneer State case provides guidance as it states a third level of clear error review. That should not be the case here. Pioneer involved the Markman factors, which we're all very well familiar with now, and involved an innocent third party. The clear error standard was applied to the balancing of those Markman factors and the factual underpinnings of those factors. Those are not relevant here when Ms. Sherman is the individual that applied for insurance and is not an innocent third party. The standard, therefore, should simply be exactly what the Court of Appeals did and exactly what I think
Counsel, good morning.
Yes.
Why is it that rescission is the only answer here? I understand, just trying to understand in a simplistic way, why is it that we have to go to right to rescission and none of the other things would apply?
Absolutely, Your Honor. Rescission has been the remedy that has been well settled in our case law for years. Over the past 2 years, rescission has been the remedy that the Court of Appeals has endorsed in multiple panels. Justice Thomas, I believe you noted it, or perhaps Justice Welch, I may have gotten it mixed up. Reformation is limited in certain respects. Justice Welch, it was you, I apologize. It's those instances of mutual mistake, and I would suggest that reformation is proper when the parties intend to continue to be contracted and want to reform the contract to meet the terms they intended. That's not the case here, where a material misrepresentation is made, an increased premium would have resulted, or indeed Progressive might not have insured her at all, and then the court ordering reformation does not actually make Progressive whole, and instead rewards that sort of misrepresentation. It's not, from a policy basis, the behavior we want to reward. So reformation would not be the proper remedy here. I don't dispute that there is case law that says it is one of the remedies for a contract. But in these scenarios, in a scenario of an insured making a material misrepresentation, it is what this court and multiple panels of the Court of Appeals has said is the sole and proper remedy. I think that decision was correct by the Court of Appeals then, to say that there is an abuse of discretion here, because reformation should not have been a remedy that was available for the trial court judge to select. So I would suggest that, to go back to the first question before you, the proper standard was applied by the Court of Appeals. De novo review of the motion for summary disposition of the material misrepresentations at issue, and then it turns to a second review, which is an abuse of discretion for the ultimate selection of the remedy. De novo appropriate for the motion, selection of remedy, abuse of discretion. That's a simple, workable framework. It's what most of the Court of Appeals panels have endorsed. Indeed, when I was trying to look this up over the last 2 years, the multiple cases that have been before the Court of Appeals on this issue, I think virtually every single judge on the Court of Appeals has used that framework. They've all sat on panels that have decided this. We would therefore state that the proper result was reached by the Court of Appeals. They did the right thing. They used the correct standard, and there was no need to remand for further balancing, for further evaluation or factual development when the factual record was well settled, and when the type of balancing that plaintiff is calling for is really that balancing that we use when there's an innocent third party involved. And rightly so, when we have the factors from Justice Markman that we can evaluate and use to balance the equities of applying a rescission to an innocent party. Here, there is not an innocent party to balance. The only party that came to the situation or the circumstances with unclean hands, or with clean hands, excuse me, was Progressive, as you noted, Justice Kavanaugh. The timing matters.
Well, but, so that may be the case here, but obviously we're looking at, you know, if we're to write a rule, right? I mean,
Sure.
it's where there, let's say we agree with you that there is an identified unclean hands on the part of the insurer, that rescission may be the appropriate remedy. But would the rule still be like in a third party, an innocent third party claim, like a BOSI claim or something like that, where you're balancing the equity, even when you're only dealing with the insured and the insurer? Would the rule still be looking at the balancing of the equity between the conduct of the insurer and the insured?
I think the Court of Appeals did exactly that when it looked at, okay, who is the actual party coming to this scenario with unclean hands? I think that's all that needs to be done. Who is the party? It's the statement of one who seeks equity must do equity, correct? So it's looking at the time of the inception of this policy, what did Progressive have, what did the insured have? Progressive is under no duty to investigate anything further. That's well settled by this court. Progressive must accept what is provided to them and issue coverage accordingly. Progressive has the clean hands, and that, in my opinion, in our briefing, that would be the rule to endorse. That the balancing is exactly what the Court of Appeals did, to look at what the actual conduct is.
Can you envision a scenario or a fact scenario where the insurer in that balancing would come with unclean hands? I mean, we have, it would have to be very narrow, right? We don't have agency
Right.
liability, like you said.
Right.
They don't have a duty to investigate the truthfulness of a statement. Is there any daylight in there?
I think it could be very narrow. You brought up the agency exception if the insurer has an entirely ambiguous application that is meant to entrap people. There's some factual finding for that. But I've yet to see that because presumably those applications and those forms wouldn't be approved by the state either. So I'll concede to you, Justice Kavanaugh. I think it would be extremely rare, extremely limited. But I think that is exactly what this case law is meant to endorse, that we don't want people misrepresenting things on an insurance application. We want them to review it carefully. They're warned multiple times on this application to review the information. We want that to be clear information so that the correct risks are being insured. We don't want to incentivize someone to, in this scenario, I think the incentive would be, you can misrepresent something on your application, okay, you get caught, and the judge says, well, just back pay your premiums. Okay, you can always misrepresent because it doesn't matter until you get caught. That's not necessarily an incentive we want.
Well, but by the same token, right, like, I mean, I get that the insurer doesn't have a duty to investigate, but, I mean, it only came up because you were gonna be subject to paying benefits, right?
True.
For an accident. I mean, none of this conduct of, we had a problem with where she was garaging it, we had a problem with who else is in the household, none of that came up until you're looking at having to pay potentially lifetime medical and on all the other benefits.
We would not have been in the situation had a claim not been made, true. But I don't think that means that Progressive is somehow in the wrong here, that they took their insured at their word. I don't think there's something wrong in that, okay, now we have a claim, now we have more information, we're going to make a decision. They are allowed to do that. They're allowed to take their insureds at their word, and then when they discover information that's conflicting, to make a claims decision. And I think they did so properly here. And I think the Court of Appeals got it right. So I would ask you to uphold their decision. If there are no further questions?
Counsel, actually, I do have one. Amicus in this case argued that the insurance company can't just automatically rescind the contract, that they have to go to court to do that. I'm guessing you have a response, and I'd just love to get your response to that.
Certainly. I disagree because I think we did exactly what we were supposed to do. We rescinded the policy, and then when this lawsuit was filed, and I should know, plaintiff accepted the refund she was given as well. She never contested that, never challenged it. She then filed suit a few months later. We immediately moved for summary disposition after confirming the facts and depositions and asked for that rescission to be affirmed. I think that's the proper setup, and that's what we've been doing practically as an industry and in practice pretty universally.
What about, though, if the plaintiff didn't in fact sue you? You've got a misrepresentation, there's an accident, you get notice, you recognize that there's a misrepresentation, you rescind, you return the premium, and there's no suit.
Yep, that's allowed. She
So
didn't
you
change
don't
the
have to
premium.
go into court to get that, the
I
ability
don't
to
believe so.
rescind.
No, the courts, or excuse me, the case law gives an insurer the power to rescind if they discover a misrepresentation. That's well settled. It is an equitable principle. It's enforced by the courts, but I've seen it multiple times where the plaintiff accepts the premium refund check the claimant, I guess, in that situation, and we move on.
Is that under the contract, or is that an equitable matter? Which of those is your basis for that?
Pre-suit contract. It's in the contract, it's in the application that we reserve the right to rescind should there be a misrepresentation.
So you would have to go to court to get an equitable remedy of rescission,
We
correct?
would do that if there was a lawsuit filed, yes. If there's a lawsuit filed to defend our decision to deny the claim, we would then argue the rescission and say, we've already made this decision to rescind, ratify that, and it's essentially asking the court to absolve us of liability for the claim. If nothing further, I'll rely on my brief. Thank you.
Thank you.
I think it's important to note that in the lower court, there was no misrepresentation found. That was part of the decision. Ms. Sherman, at the time that she took out the policy, was in fact in Clinton Township. The question that came about was, where was she domiciled? But that was not the question in the policy. The policy just asks, what's your address? And the equitable decision that ultimately came from the trial court took into account all of these issues. And I think in Bozzi, there's a quote in here that says, this court has recognized that the equity jurisprudence molds its decree to do justice amid all the vicissitudes and intricacies of life, and that equity allows complete justice to be done in a case by adapting its judgments to the special circumstances of the case. That's sort of exactly what we are looking at here. When someone has a flood in their house, and they move to their daughter's house, they shouldn't have, be subject to a rescission because of that. That we should be giving leeway for people to encounter life issues and still have insurance. And that's ultimately what the trial court did, is it balanced all of these potential issues that come about. And again, to address, whether or not the insurance company has unclean hands, the insurance company is the sophisticated party here. They're the one who knows.
Counsel, looking at this from like just a general perspective.
Yes.
In terms of how we move forward in this case, how do you distinguish between a mistake and an intentional act?
A mistake in
A mistake on the form versus something that you did intentionally. And is there a way to decipher that? Where a person just made an innocent mistake versus concealed information from the insurance company.
So I think that Progressive's policy kind of contemplates this, because it has a section for, we can rescind if you commit misrepresentations about certain things, and then we can change the premiums if you give us the wrong information about certain things. So wrong information, like a mistake, would be address. I mean, that changes your premiums amount. It doesn't change your insurability. If you lie about whether or not you have pre-existing injuries, or if you don't have a license, or you're not 16, you're not of the age to drive, those are material facts that affect your insurability. That is fraud right there, because if you say I can drive but you can't drive, that is a completely different issue than a mistake of listing where you're living. And the lower court found that she was actually living in Clinton Township at the time.
Thank you.
So I want to be correct, because my understanding is that the trial court found that there wasn't fraud, but that there was a misrepresentation. Correct?
The actual quote from the trial court was, I'm not making a finding as to misrepresentation, but I'm reforming the contract to the Detroit address. I think I left that on the desk over there, but.
So you read that to say that she didn't find whether there was a misrepresentation as opposed to determining whether or not it was intentional or innocent.
Sorry, can you repeat that?
I mean, when she says, I'm not making a finding as to misrepresentation,
Yes.
wasn't that whether or not it was intentional or innocent, as opposed to there wasn't a misrepresentation? Am I correct in understanding the record?
I believe that's what happened, yes.
Okay.
I mean, I think you can infer that from the actual language that was used. It was an oral opinion.
Okay. Thank you very much.
Thank you very
The
much.
case will be submitted and the court stands adjourned.
Thank you. Happy holidays, everyone.
Thank you. Same to you.